My name is Jared Mugendi. I am an advocate of the High Court. I always wanted to become a lawyer from a very young age. And I involved myself in activities that would align me in that direction early on. For me, it was not about the books, really. It was about what I saw law doing. Law was rectifying ills of the society, An injustice has happened somewhere and a lawyer walks in and that is fixed. So I really wanted to be that person from a very young age. I have a law firm. This is Jared Mugendi Advocates, where we practice litigation, constitutional law, alternative dispute resolution, among other specialties like data protection and contract management. Yeah.
People feel like, or before you really actually understand what law entails, people think, hii ni job yenye iko passive, ni theory too. It's good you mentioned.
Yes.
A problem occurs.
And
then a lawyer comes and solves.
Yeah.
It's as practical as medicine.
Yes, but unfortunately, we lawyers are some of the most hated people in the society.
Why is that?
Yeah, I think it's a phenomenon that is strange because we tend to think that some of the people who come through for you in the most difficult circumstances are the lawyers. Traffic stops, unfair arrests. Yeah. So akufae kwa dhiki, sijui kwa nini kwa lawyer sio rafiki.
But I think ni kutojua, because once you interact with lawyers, you get to know what that means, what that profession is all about, and what they go through, and you even appreciate. All right. We just delved deep right into it. As I talked earlier, or as I introduced earlier, tulikuwa tunazungumzia ama tulikuwa tumepanga kuzungumzia separation of powers, sovereignty of the people, rule of law, and the supremacy of the constitution.
Yes.
Yeah, kabla hata tuende kujua what sovereignty of the people really means, separation of powers. Tuanze na history. Juzi tukisikia watu wanasema, the president is muscling the judiciary to, sound the way he would want them to.
Yeah.
And somebody was saying, no, ni another arm of the government. Chief Justice, you're the president there. You cannot be summoned to State House and stuff.
Yeah.
You could just start by commenting on separation of powers.
Okay. I will start by beginning to address sometimes there is a way information is packaged to the populace, and because you can influence perception with what is currently out there, it is very difficult to give an alternative point of view without being deemed as you're in error. And that will be the basis, because I will say something that is not in the popular. The Constitution does not have, our own Constitution, if you read it, does not have anything. There's nothing called separation of powers in our Constitution. You can check it online. There's no separation of power. What the Constitution upholds is constitutionalism. When you do an action, you are bound by the Constitution. The Constitution says whenever anyone applies, enacts, interprets, applies the Constitution, you are bound by the Constitution and the national values at Article 10. So the judiciary is an arbiter of disputes, right? But it does not have the sole preserve of justice. And that is the difference, which may not be very apparent to so many people. So that when the Chief Justice is, say, meeting the President, it is not discussion of a court case. Yeah, I hope the dichotomy is is emerging. Like I said before, I was about to introduce a very divergent opinion from what is out there. They were not discussing a case. Fine, I understand the optics that it's an independent arm, but independence is functional. For me, as long as the judiciary has not been hampered to do its actual job of interpreting disputes or mediating disputes, we could cut the Chief Justice some slack. But then again, that would get me in trouble with my law society leadership, who have a different opinion. The Chief Justice should never be seen with the President, whatever they are discussing. But for me, it is to understand that separation is not in essence that you are there, I am here. Separation is functional, that I am exercising my role, but the dispensation of justice is not a preserve of one arm of the government. The executive also is supposed to preserve justice. The parliament is also supposed to preserve justice. Now, we can have a discussion on whether one arm has influenced another not to exercise their functional independence, and that is a separate conversation, because that interplay must be understood. Yes, that is how I would take it. So the idea that one arm has influenced another for me is a separate conversation from, has separation of powers been breached?
We will be getting back into that conversation of separation of doctrinal powers. But right about now, I would like to have you tell the listener and I what the concept of sovereignty of the people is.
Yeah. Sovereignty lies at the basis of self-determination. It is the ability, because let me borrow some principles from the Christian world. Whenever any people meet, the idea of government exists. If, for instance, the government of Kenya did not exist and we were all together, we would all clamor to have a hierarchy of, you become our leader, we will follow you. That's why we have the chiefdoms, we have the head of the home. So the idea of the government exists in every human being. Now, right to self-determination lies at the basis of sovereignty, that the people choose what will apply to them. They accept the rules that they apply to them. They can undo the rules that apply to them. They chart ideals about them, the way forward, what their future is going to look like. And that, for me, is the essence of sovereignty. It is not someone making a decision on behalf of. It is the people collectively choosing a particular path. Yes.
What is the role of government in all this?
Now, government is meant to serve the sovereign. It is a representative. If you look at Article 1.1.12, it exercises delegated power of the sovereign. So they act on the interests of the sovereign. And that interest of the sovereign must be aligned to what the sovereign desires. Now, the sovereign have decided to form a constitutional document, a constitutional charter. Now, that constitution is what guides the sovereign. This is what we desire. Stay on this path. Represent our wills, our desires, our aspirations. That is why we cannot all travel to Paris when the president is traveling, in order to solve the climate issue, which is a concern for the sovereign. He goes there on our behalf, signs on our behalf, and so on and so forth. So that is the interplay.
You had mentioned along the way that government is representative sovereignty, so to speak. Does this mean that there are other forms or types of sovereignty, or other ways that sovereignty could be exercised by the people?
Of course, the people can choose to exercise sovereignty directly or through their representatives, and those representatives are now in those three tiers: the executive, the legislature, and the judiciary. Now, it doesn't mean that we have different forms of sovereignty, but we have different people who have been assigned. I wouldn't call them people, entities that have been assigned that responsibility of delegated sovereignty. Yeah.
Direct sovereignty. Yeah. Perhaps you could comment on that.
Very tricky.
Yeah.
Very tricky in today's climate. That's why, especially when you asked me about separation of powers, I was a bit cautious, because some of the things we say, at the essence of it, if the public say we want something, we have already said in Article 1 that we are giving that delegated responsibility to government. Now the question would be, do we say that the government is exercising sovereignty on our behalf? If the government says we the people, that is on one hand. On the second hand, you have the government, the opposition, saying we the people. Yeah. And that is one of the problems that I was sharing with you when we bumped into each other. Even in the political parties conversation, you could see that challenge of trying to understand who is we the people. Are, say, political parties representatives of sovereignty? You follow? So that puts us in a very, because at the essence of it lies the question, who is this that directly represents we the people? And that question was tested in the BBI case, where the president felt that I am also part of the people. I am a representative of the people, so I can initiate an amendment to the constitution. Yeah. Mm-hmm. So if you look at it from that lens, you can actually empathize. He was not, other than the other political things that we can discuss later, that dilemma that we have come from a very imperial presidency to an era of constitutionalism, where anything you do must be constitutional. That's where you can see that challenge arising. Yeah.
What exactly does or do people who form up this arm of the government do for the benefit of the Kenyan population?
Thank you. In this current climate, we have a lot of, I would not want to say, right now things are so dicey in Kenya. You have to be very careful when you say or define anything, Mabea, but here's what I would say about the executive. The executive is vested in the president and the vice president, and they have a role to do They are also part of what we discussed earlier, exercising delegated sovereignty. That is why the president is a symbol of national unity. Yeah. So, and the executive will do things that you as Mwananchi cannot do. You cannot go to Abita. We cannot all sit in Uhuru Park to discuss international contracts or treaties. The government does that on our behalf, headed by the president. If we are receiving a head of state, we are not all a state house. He does that on our behalf. Yeah. If we are hosting national celebrations, he's our symbol, our representative of national unity. So he heads an executive function, signing bills into law. That is his role. Yeah. And he has the Constitution has designed people who are supposed to assist the executive to do his role. You have cabinet secretaries. You have the Attorney General, who's, in legal circles, we say is the largest law firm. Is the Attorney General's office. Yeah. Because it hosts, the government has the highest number of lawyers handling the highest workload. And the Attorney General advises the government more so closely the executive, on the way it should proceed. So, not to sound too technical, but that would be the summary of what the executive would look like.
And now let's move to Parliament.
Yeah. So for Parliament, you have a constitutional design put the National Assembly and the Senate. Now, the National Assembly is representative of the 290 constituencies. Then you have the Senate, which has the 47 senators, and so on and so forth. And now the women reps. And remember, that came from a background of exclusion of women. We were trying to affirmatively include women in our political space. Now, and of course we have the youth and persons with disabilities in there as well. So the executive will chart and debate rules that have the force of law. And no other body can do that. That has been given that we have that delegated responsibility we have given to them is to make laws that have some force. So if you and I sit here and come up with a rule, it will not apply to the entire country. It will be between you and me. And that will be ideally a contract, But if they make a law, say the Advocates Act, it has a force of law applying to the entire sovereign in exercise of the delegated responsibility that we give them. If you go to the judiciary, they are the arbiters of disputes. They uphold the rule of law. They are not the only ones who do that, but that function of mediating disputes comes from a historical background, because you see, we obtained our constitution based on the Anglo-Saxon historical account. Now, we had our own systems of justice, but then because when the colonialists came, they left a system which we are now trying to adopt and to transform, to tailor to what we have. Though we have achieved some success or not, we can see now judiciary has been given that it's a forefront to mediation of disputes. But judiciary does not solve all the disputes, because justice can be expensive. Justice can really be expensive. And in these current economic times, I think everyone can agree, if you don't really need to go somewhere, you don't need to pay for it. So you will opt for an alternative method. And the Constitution, having noted that, was able to adopt alternative methods of dispute resolution, But the hallmark is they must all be constitutional. Yeah.
What do you mean by independence of the Constitution?
Now, independence of the Constitution, some of these terms, the way they are defined, they maybe I'd want you to clarify, but what you mean by independence of the Constitution?
Like, typical, what we were discussing before we came on air, you see somebody saying, you're a president of a whole arm of government, you're not supposed to be...
Correct.
You're not supposed to be, bowing down, so to speak, to another president of another arm of the Constitution. You should exact your authority. What you say in consultation with individuals and in that arm, I should really carry the day. That is what comes into my mind when I hear the name independence, and then there's the sentence of the judiciary.
Yes.
Yeah. Is it even a reality that the judiciary can be independent in that way? Or, it's just, language too has got its intrigues.
True.
The term independence maybe could be too strong for what we are thinking. Impartiality is, and the ability to make choices and chart your own course would mean.
I mean, it's good that you asked, because when I started before, I said it is a very dicey topic to delve, especially in the current climate, where the Chief Justice went to talk to the president. Why is she going to talk to the president? The opposition was up in arms. And so I have a small circle of a group of friends. We discuss what happens legally every week. So we were looking at this issue and asking ourselves, okay, what exactly is the role of the judiciary? Has the role stopped, or it has been hampered? Political arguments aside, and the optics, has the role been stopped? Has it been hampered? If we say separation of power, is it even constitutional language?
Which office can exercise judicial authority?
Okay. Judicial authority is vested in the judiciary. And some of these words in the legal profession are quite key. Judicial authority is vested in the judiciary, and it is derived from the people. The proclamation a judge makes, he makes on behalf of the sovereign. So it is vested in the judiciary as a whole, because the judiciary is different. You have the Supreme Court, Court of Appeal, High Court, and of course the Magistrates Court. You have the Kadis Courts. Remember, we have a social contract idea of government. A social contract idea of government is, if a member of the society has been wronged, but let me begin a little bit further. In a social contract, we say, you give away some of your rights, I give away some of my rights, so that we can enjoy collective benefit. So, if you're injured, instead of you, if say you are robbed, you will go to the police. You will not take up arms to chase the robber, because you have ceded part of your right to self-defense to the collective protection of the society. Similarly, they exercise that judicial authority to make proclamations with force of law and with impact on behalf of the citizenry. So judicial authority is vested in the judiciary.
Now, what are some of the principles, if there is, that govern the exercise of that judicial authority?
I will discuss maybe one that is the most thorny right now, because I can see you really tilted me towards current affairs. The one is really the rule of law. It is a principle that permeates, judicial decisions. That an individual is not allowed to do whatever the hell they want without limit. You get? That is why we are able to, citizens can go to court and check the government. Right? An individual is not allowed to do whatever the hell they want. Number two, justice. They dispense justice. They mediate disputes. Now, you see, justice is not, like I said before, is not really a preserve of the judiciary. While the judiciary maintains the judicial authority straight from the people, what they proclaim, the determinations that they make, should be able to dispense justice. Yeah, it's a principle. So let me begin by rule of law. Like I've explained to you, rule of law was not meant to be procedural. It was meant to be substantive. Yeah? If we all follow the law, if we don't exceed the limits of the laws we have allowed ourselves to be limited by, then we can all prosper in our different lives, in our civil life, political life, social life, and economic lives. We can prosper. Failure to adhere to the rule of law now leads to what? Anarchy, right? Societal dysfunction, civil strife, and a host of other bad things that follow. Now, rule of law has within itself that core value or principle which I just shared with you of justice. What is just is not necessarily what the court determines. Right? Your sense of justice is not drawn from judicial authority or a judicial determination. Your sense of justice comes from your essence as a human being. And I'll explain that so that I'm not misunderstood. We wrote an article some time back with my friend Dr. Ojwang called Bargaining in the Shadow of Law. You remember during the COVID times, Luos, when they were burying famous musician Ben Jachiga, they broke all the COVID rules you could imagine. They were in a crowd. Some were wearing masks that were 3-4 days old, and all those things. For them, the sense of justice was not the written law. It was already proclaimed, and if you could go to court, you would be prosecuted that you breached COVID laws. But the justice in the Luos who were burying Ben Jachiga was our cultural values supersede the written law. And number two, which is most critical, this law applies to us if we accept it. Very critical. So their own sense of justice enable them to choose what to obey and what not to obey. So, rule of law checks all of us to ensure that, number one, we are there and not become now anarchists, that we can now do what I said before, whatever the hell we want. But you remember that is a very specific context in which the common law is interfering with a cultural right, which is an essence of a human being. That even if I was to proclaim to you right now, you are not to see your child for a variety number of reasons, as a father, you will not be okay. You will obviously want to obey the court to avoid, and for one, those determinations are given for variety of reasons. I'm not limiting, but the essence of you being as a father may not necessarily be recognized through the court system. And that's why we must always be careful not to limit justice to courts only. Yes.
We want to really
What
know
is a court?
What is a court?
I would say, let me use a common phrase. A court is like a temple of justice, where the priest is the judge, the deacon is the lawyer, yeah, and the ushers are, of course, the bailiffs, and we have the litigants who come to seek justice from the courts, who walk into that temple. So the court is not the building. The court is not the structure itself. When you go to Milimani, that distinct structure you see there is not, or at the Supreme Court, that is a courthouse. The court itself is properly constituted when there is a judicial officer, present in court, about to make a determination of a thing or two, and it is properly constituted. When a lawyer or a litigant walks into court and say the judicial officer has not arrived, you find people seated, right? But when a judicial officer walks in, we all stand and bow. The court has arrived. Yeah? Like what Zuma playfully was trying, not playfully, rather, he was irritated by someone trying to attack him, and he had just arrived in a I've just arrived. So now a court becomes properly constituted, both with a clerk, with the litigants present, with the counsel. But so the court is not a courthouse. Let's start there. Yeah.
Sasa, now that we understand the court is not a courthouse ni ka building tu,
Courthouse is a building, because there are courts that are not actually housed in buildings. If you go to Siakago Law Courts, the court is under a tree.
Kabisa.
I mean, some courts are so. There is a court that is sitting outside on a tree. Yeah, and you cannot say that is not a court.
Is there any structure of the court system in Kenya? Ama kesi yoyote inaweza peleka to anywhere, anytime, any place?
Of course not. If you, there are different disputes are taken to different courts, and it is for good reason, because otherwise, if you lump all cases into one court, you may have some disarray and I'm sure the judges who have been here have tried to explain the rationale, because of the high volume of cases, the complexity of cases, nature of the cases. It was the wisdom of the constitutional framers to divide those categories of courts and give them a hierarchy. Okay, so the highest hierarchy, we have the Supreme Court. Now, the Supreme Court, the most recent thing you can remember about it is it has determined, other than them punishing one of our own, the presidential petition. So they are the only ones who can determine a presidential petition. That is the Supreme Court. The other issue that they determine as a right is matters of general public importance that are either certified by it or by the Court of Appeal. Yeah. And they also give advisories. So appeals don't just go there. Appeals must be certified to go to the Court of Appeal, because the original jurisdiction, right of a court to hear a matter, say, for the first time in a presidential petition, is Supreme Court. That is their original jurisdiction. They can also give advisory opinion. They can also exercise appellate jurisdiction on matters of general public importance once they are certified by the Court of Appeal or by the court itself. Okay? That is the appeal route. And then, of course, you have the Court of Appeal, which exercises appellate jurisdiction from matters which are heard in the High Court. Now, the High Court has a lot of latitude because they have original jurisdiction in some of the cases, like murder.
Original jurisdiction to mean?
Original jurisdiction literally means the right to hear a case for the first time. And I'm trying to simplify some of these concepts because, like I told you before, I don't want listeners to assume law is for lawyers. Law is, like I said before, and we always emphasize this with some of my friends, it is a tool for social healing. So the High Court has original jurisdiction in civil criminal matters, unlimited. Yeah, you can initiate constitutional interpretation matters at the High Court, right? The High Court can also give constitutional interpretation, determine whether a bill or fundamental right has been breached. Article 24 of the Constitution gives the criteria which should be followed in determining whether a right of fundamental freedom has been breached. And the High Court gets to determine those. So they have a very wide latitude and a very heavy backload of cases. Then you have the specialized courts that we have, and those specialized courts, like the ELC, ELRC, and we say they are not the High Court, but they have the status of a High Court. Yeah, you cannot take murder cases to ELC. ELC gets to determine land questions only. Environmental Labor Relations Court only handles those specialized cases. But there are judges who have the same status of the High Court. And those judges, actually, if you see, because of the level of speciality, very, very brilliant minds that sit in some of those courts. I had the privilege of attending a webinar recently by one Judge Ogutu. Very, very knowledgeable in the area and in a wide array of constitutional issues, because they get to read a lot and to also see a lot. Then we have, of course, the magistrates' courts, chief magistrate, principal magistrates, resident magistrates, the magistracy courts. Then you have the Kathy's courts, and you have court martials. Then that one applies to non-civilians, members of the judiciary. Now, the hierarchy is important because, a case can start from, say, like we said, the High Court has original jurisdiction, unlimited original jurisdiction in civil and criminal matters. Then, when you go to the Act, they define, say, the limits and say, this case up to this amount can only go to the magistrates. It is not to prevent you from accessing the court you want. It is for good order and good measure, because can you imagine we all lumped our cases at the High Court? What would be the result? It would be a very complicated and borderline anarchist kind of scenario.
It will be chaos.
It will be chaotic, They're also human beings. But if you cascade, they're able to be solved in a lower tier before they come up. The higher they come up, perhaps based on the complexity, perhaps based on the nature, the amount involved, the people the dispute affects, the class of people it affects. That's what you saw in the BBI case. It captured the attention of the nation. Yeah? And the High Court, perhaps I should also mention, in some of those cases, the Chief Justice is required to form a panel. Yeah, you can apply to form a panel, the Chief Justice to form a panel to discuss an important constitutional question that will need an uneven number of judges. That's what you saw in the BBI, Justice Joel Ngogi, who was now as he then was, Odunga as he then was, and the rest of the members on that panel of judges. I think I have tried to summarize, not to sound too technical, I hope.